11 o'clock. Both of you will be here. If you're not, or if I don't have good reason for you not to be here, present it to me in advance.
She says she's surprised there's even a trial today.
The boss was responsible.
Not. You're not? Her lawyer is not?
I do my best.
This is completely, I've done this for 45 years, and I've never heard of such a thing.
The court had called People versus Donald Marion Fenton for a scheduled final pretrial, which required attorneys representing both sides to be present in person. However, defense counsel George Sirkin failed to appear in person and instead appeared via Zoom, stating that he hadn't received any notice of the hearing for that day. But there was a problem. Defense counsel George Sirkin had called the court clerk the day before and informed the clerk of his decision to appear at the hearing via Zoom instead of in person. When the judge questioned how he knew there was a hearing if he hadn't received any notice, things got heated.
Court calls the People of the State of Michigan versus Donald Marion Fenton, case number 25542 SD. Appearances, please.
Nate Carnes on behalf of the people.
Good morning, Your Honor. George Sirkin on behalf of the defendant.
Mr. Sirkin, why are you not here?
Your Honor, I was informed yesterday in the afternoon by the clerk to be here at 8:30, and unfortunately, it takes me over 4.5 hours to drive. I could not make those kind of arrangements on such a short notice. And the problem also is, Your Honor, that I have a number of motions to file next week, and because of the holiday on Monday, I have to get them out today or tomorrow. I would always...
Mr. Sirkin, you received a notice back on April 16th of today's date.
Your Honor, if I may, my recollection and my notation in the calendar was that it was going to be on May 22nd. And also on May 29th, we're going to have a final pretrial. My client also said he made a note of that date. Now, when I filed my motions last week, I received...
Yeah, we'll get to your motions in a minute. Where are we at with that?
All right, well, here.
Does not make sense to me. Mr. Sirkin, hold on.
Yes, Your Honor.
I don't show that it was ever set for the 29th. We have the final pretrial that was set for today at 8:45, and then the motion hearing that was set yesterday at 9:45.
Yeah, so my clerk is telling me, as is my file, we were never set for a final pretrial next week, that we are set, the notice in the file is set for today at 8:45. That was sent out on April 16th.
Oh. Your Honor, I received the court notice yesterday with the date of May 21. I have the envelope. It was postmarked May 20th.
It was, and my staff tells me they had a telephone conversation with you about that date being set.
A telephone conversation to set it to 9:45 instead of 8:30, and I agreed.
During the exchange, defense counsel Mr. Sirkin repeatedly interrupted Judge Wiggins, which forced the judge to issue a contempt of court warning for his conduct. Moreover, the judge issued a clear warning that failure to appear at the next hearing without advance, documented justification would result in contempt sanctions.
So my staff tells me that they mailed notice of yesterday's motion to you after having a conversation with you, advising that that time was okay. And then we're still here today, and you're not.
Your Honor, the only notice I received was the notice I received yesterday. And that notice was received yesterday, and I have the envelope showing that it was postmarked on May 20th. If I have an opportunity to...
For what day?
Person, I will bring it with me, Your Honor.
What day did you that notice that you received that you just referenced, what hearing was that for? Okay, so that was yesterday. That was yesterday.
Yes, that's what the
when
notice
did you
says.
Receive no?
I received this yesterday, Your
Sir,
Honor.
let me answer the question. Ask the questions. All right. You're finding yourself very close to contempt.
I'm sorry.
When did you receive notice of today's hearing?
Yesterday in the afternoon.
Today's hearing, you received notice yesterday?
Well, no, not today's hearing. I'm sorry. I had a conversation with the court clerk yesterday about today's hearing.
Yeah, when you advised them that you would be appearing by Zoom, and I said, no, you're not. The question
understand,
is,
Your
when
Honor.
did you receive notice of today's hearing?
It was about 2 o'clock in the afternoon.
That's when you had the conversation with my staff. When did you receive notice on paper of today's hearing?
Verbally, yes.
No, on paper, when did you receive it?
Receive what, Your Honor?
Good God. When did you receive on paper the notice of today's hearing?
I have not received anything on paper of today's hearing.
Then how did you know to call my staff yesterday and tell them that you were going to appear by Zoom?
That's correct.
All right. All I can say is it's a good thing you are not present in my courtroom today, because you would be finding yourself an inmate at the Wexford County Hilton. What we're going to do is we're going to set this for next week on Wednesday. We will address your motion and we will address the final pretrial. That will happen at 11 o'clock. And if that doesn't fit with my docket, we'll squeeze it in at 11 o'clock. Both of you will be here. If you're not, or if I don't have good reason for you not to be here, presented to me in advance, you will be in contempt of court. Do I make myself clear?
On May 9th, 2024, Judge J. Cedric Simpson presided over what should have been a routine bond modification hearing in the case of People versus James Whitley. But what unfolded next was anything but routine. The prosecution had filed an emergency motion under Michigan Court Rule 6.106, a procedural mechanism that allows the court to modify pretrial release conditions when new information emerges suggesting either a risk to public safety or a violation of existing bond terms. This isn't unusual. Judges handle these motions regularly. But here's where things went sideways. As the hearing was about to begin, defense counsel representing the accused, James Whitley, objected to the state's request for an urgent hearing and challenged the filing, stating that they had not received adequate notice or equal access to the court compared to prosecutors, indirectly accusing the judge of favoritism and denying a fair trial. That statement triggered a furious response from Judge Simpson.
This is People's emergency motion to modify bond in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor. They don't call her to show up. She reached out to a friend of my client's
Call her to show up to do what?
today to say, I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know if 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
Upon hearing these unfounded allegations, the judge recessed the court for approximately 15 minutes. When he returned, he had some choice words for the defense attorney.
Corporal County, Washington, session, the Honorable J. Cedric Simpson.
You may be seated. Court recalls the case of the People versus Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newton on behalf of Mr. Whitley, standing to my right. Can you state your name before, please? James Bennett.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn. The case, the very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for 2 reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow.
Even though Judge Simpson had the authority to modify the bond immediately, without holding a full adversarial hearing under Michigan Court Rule 6.106, subsection H, he refused to punish the accused for the defense attorney's ignorance and instead adjourned the hearing to the following day. On December 12, 2025, the case of the State of Texas versus Sarah Samiski came before the Jefferson County Criminal District Court. The case was set on that day's docket to determine whether both sides were prepared to begin trial in a felony matter. But the moment Judge John B. Stevens Jr. looked at the defense lawyer, he knew something was wrong. Here's the legal foundation. The Sixth Amendment of the United States Constitution guarantees every criminal defendant the right to the assistance of counsel. Not just any attorney, but effective representation. That means an attorney has an obligation to communicate with their client, prepare strong witness statements, and develop an effective defense strategy. In fact, in felony matters involving serious injury or death, Texas trial courts are required to ensure that a trial is not commenced under conditions that would deny a defendant meaningful legal representation. This is not optional, especially when someone's liberty or life is on the line. And Judge Stevens' instinct was correct. This lawyer had a documented history of ghosting his clients and missing court dates, essentially depriving them of their rights under the Sixth Amendment. When the judge discovered that the attorney had repeated the same pattern of conduct with Ms. Samiski, he wasn't ready to let it slide.
Have you talked to your client lately? The last one said they hadn't talked to you for 4 months before the trial, but that's a problem. 2 of them said they hadn't talked to you for 4 months.
I've talked to her, not recently.
When? I mean, aren't
This, even though,
where's Sarah Samiski?
the first person here, that
I'll be.
this involves the death of the child. That's the injury is death.
Okay.
State is ready.
All right. Okay, and y'all are ready? All right. Y'all been talking with her? You've been working with him? When was the last time you spoke with him? A month ago, and we're in trial today. My God.
I have been trying to get a hold of his office and it likes this, like get the phone number and everything. And I also tried to message him and then I'm doing that.
It's a trial today. Yeah, but y'all haven't talked to y'all, I mean, we can go to trial right now and we're ready.
And only Fridays from 1 to 4, and I've tried to call and haven't got anything.
That's
Yes, I did. I was like, not listening to
It's the day for trial, you know, you got to strategize and prepare and, you know, rehearse your testimony.
letter and the phone call from him.
You didn't even know you're going to be under trial.
I didn't get anything from him. I didn't get any letter, any phone call.
Honest. I'm sorry.
I didn't get anything from my.
That's not. Yeah.
But that's how I had got my whole student shots. That's how I've always gotten hold of it.
Here's texting him Facebook Messenger.
I don't know. You know what you know what I would say. I've done this for 40 years and I've never come to a trial without being prepared. She says she's surprised there's even a trial today.
The boss was responsible.
You're not? Her lawyer is not?
I do my best.
What have you done? Oh, no, okay. All right. Well, I've never heard, this is completely, I've done this for 45 years and I've never heard of such, I've never heard of this.
I didn't hear until
People get ready. And then the last, what they said last week when you weren't here at trial docket. So we had a trial docket, you didn't even show up.
I was in the trial.
Sir, you interrupted me just then. Sir, you interrupted me when I was speaking to you. Sir, I'm speaking to you. I didn't finish my sentence, if you'd be so kind. We had a trial docket. You never showed up for the trial docket, and the people there said they hadn't talked to you in 4 months. And it was obvious y'all weren't going to be able to go to trial. We had to go to trial on another case.
Notice order from Judge.
Sir,
trial.
Sir, once again, those are things you need to speak to me directly for, because the protective orders, look, we know what's going on with protective orders, and this court has a fair opportunity to be heard on its protective orders.
It wasn't a protective order.
Well,
I did pick a jury.
This court generally doesn't do that, but I know some courts do, but I'm supposed to find out way ahead of them. I should know way ahead of a trial when that's being pulled, because the courts have a fair opportunity to be heard, especially ones that don't do the protective orders like I do. I know what goes on, and in some of the counties, you know, it's subject to abuse, and that's not fair to the people who are the 22nd largest county with the 16th highest crime rate, like ours. I think we have some prioritization for the people of Jefferson County. You can't go to trial right now. You know, y'all aren't ready for this.
Go to trial, but we didn't know when, and that's the first thing I heard.
Okay, well, there's got to be preparation, and you just can't impromptu come up here and start testifying.
When asked about the reason for his conduct, the lawyer offered a series of lame excuses. Ultimately, the matter was continued to a later date, with clear instructions that the trial would not begin until the defense was meaningfully prepared and ready to proceed.